Everybody.
Morning.
Thank you for being here. Are you all set?
Yep.
All set?
Yep, they're ready.
Great. Welcome to the June 9th, 2016 meeting of the New York City Campaign Finance Board. The first order of business is the approval of the minutes from our last meeting on May the 12th, 2016. Is there a motion?
So moved.
Second?
Second.
All in favor?
Aye.
Aye.
The minutes are approved. I will provide a brief report from the board. Again, welcome. New Yorkers have plenty of voting to do this year. Congressional primaries will be held in little more than 2 weeks. State legislative primaries will be held in September. And of course, voters will elect a new president and cast ballots in all of these races in November. There are choices for New Yorkers to make at the municipal level as well. Voters in sections of the Bronx and Staten Island will elect council members to represent them in city government. Candidates who wish to join the city's campaign finance program for the elections in city council districts 17 in the Bronx and 51 in Staten Island must do so with the Campaign Finance Board by tomorrow, June the 10th. The program provides qualifying candidates with public funds at a 6-to-1 matching rate for the first $175 raised from city residents, which means a $10 contribution is worth $70 to a participating campaign. The matching funds allow for more candidates to run for city office without having to rely on big contributions from special interests. That, in turn, helps ensure that city voters have more choices when they head to the polls. Yesterday, Governor Cuomo issued a proposal to strengthen the definitions of coordination in state law. His proposal mirrors the strong and clear standards that this board has been applying for years to ensure candidates and independent expenditure committees remain truly independent. Unlike state or federal regulators, the Campaign Finance Board has a long track record of assessing substantial penalties to candidates and consultants who violate those standards. Clear standards and strong enforcement help protect the city's system from unlimited, undisclosed, unaccountable money. Governor Cuomo and all state lawmakers should know that New York City's matching funds program is more important than ever in helping average New Yorkers make their voices heard in our elections. Several candidates used public matching funds to overcome massive independent expenditures against them and win election in 2013. This is why citizens and lawmakers from Maryland to Illinois to Oregon are using New York City as a model for reform. We welcome efforts to strengthen campaign finance laws and have clear standards for combating the large influx of money after Citizens United. I will now turn to Executive Director Amy Loprest for her report.
Thank you, Chair. I have just a few things to note. After the last board meeting in May, I testified before the City Council on the board's budget for the fiscal year starting in July. That testimony was interesting. We talked about some policy issues as well as the budget numbers. I also want to acknowledge that last night our Director of Voter Assistance was acknowledged by Urban Word in recognition for her work on the Youth Poet Laureate, and so I'd like to congratulate Onita Caramares for that honor. As Chair Gilhern mentioned in her testimony, there is a congressional primary in a couple of weeks. Our online voter guide will be available for voters to get information about those congressional primaries and the people running in them early next week. And finally, on a more sad note, I want to recognize the passing last month of a former board member, Martin Begun. Marty Begun had a long career in public service and community relations. He ran for many, many years a private consulting firm and served on very many governmental and private entity boards, including the Campaign Finance Board from June 1996 until September 2000, and we acknowledge his passing.
Thank you. The next order of business is a candidate appearance. The candidate is Councilmember Jumaane Williams, who I believe is here with us this morning. Welcome, council member. Please have a seat, sir. If you could state your name for the record, council member.
Councilman Jamani Williams.
Thank you. And members of the staff,
Bethany Persky, CFB attorney.
Aaron Burns, auditor.
welcome. And I'll turn it over to the executive director to walk us through the procedure.
So, as you know, what will happen is the staff attorney will give the board a brief recitation of the issues before the board today. You will get an opportunity to present whatever information you would like. The staff may have questions, the board may have questions. The board will break for executive session to discuss this and other pending enforcement and litigation matters, and then come back to vote. And so you're welcome to wait for the board's vote, or if you are unable to wait, the board, someone from the staff will call you immediately after with the results of the board's decision.
Hey, good morning, Executive Director Loprest, Chair Gilhern, members of the board, Councilmember Williams. Before the board is the matter of the Jumani Williams campaign in the 2013 election for City Council District 45. Mr. Williams was a participant in the program and received $46,200 in public funds. CFB staff recommends that the board find that the campaign committed the following 9 violations: failing to report bank and merchant account statements used for campaign purposes, failing to provide bank and merchant account statements, filing a late disclosure statement, accepting contributions from corporations, limited liability companies, or partnerships, accepting contributions from unregistered political committees, failing to document transactions, failing to demonstrate that spending was in furtherance of the campaign, making impermissible post-election expenditures, commingling campaign funds with funds accepted for a different election. CFB staff further recommends that the board find that the campaign must repay public funds. The campaign does not contest the violation for filing a late disclosure statement, but contests the remaining recommended violations and penalties and the public funds recommendation.
Thank you, Madam Chair, Madam Executive Director, the rest of the board. We do have some things I'd like to read in response. We're not contesting all of them. We are contesting a few. First, allegation 7. The allegation is that a committee made $6,540 in spending that it failed to demonstrate was in furtherance of the campaign. Campaign Finance Board CFB staff is recommending a $1,501 penalty, which is approximately 25% of the alleged non-campaign spending. We assert that CFB staff allegation is at odds with both the law and the facts. First, the relevant law is in Section 3-7221 of the Campaign Finance Act, which defines campaign expenditures. This provision was added by the City Council in 2007, directly in response to concerns about how the CFB was interpreting the law and what is a campaign expenditure. Paragraph B of this definition lists 10 reasons why an expenditure would not be in furtherance of a political campaign for elective office. Of the 16 expenditures at issue in this allegation, only 2 to 1-800 Flowers and Crown Trophy of Yonkers, which total $471.89, even arguably fall within a prohibited category in paragraph B. Category 10, gifts valued over $50 for the purpose of expressing gratitude, condolences, or congratulations. The penalty for these 2 expenditures would be $118, and we are not contesting that. There are 14 other expenditures in this allegation that we are contesting. The next set of 5 expenditures were to Florimond Catering, Temple Beth Emeth, Grin Cap United, and 2 to Damien Reed. None of these expenditures violate any provision of the Campaign Finance Act or CFB rules. These 5 expenditures total $450. Damien Reed totaling $150. CFB staff claimed that it was not a proper use of campaign funds to pay Mr. Reed to photograph street naming ceremonies because these events stemmed from the candidate's duties as a sitting council member. But there is no prohibition against the committee paying for such photos in the law. Rather, the law expressly states that expenditures for community events are presumptively campaign expenditures. C 3702-21A3 of the Campaign Finance Act. CFB staff have not overcome the community event presumption as applied to the expenditures to Mr. Reed for street naming ceremony photos. The $300 total expenditures to Florimond Catering, Temple Beth Emeth, and Grin Cap United were rejected by CFB staff because the ads that were purchased included the City Council seal. The CFB staff relies on CFB Advisory Opinion number 2007-6 of December 21st, 2007. That advisory opinion, we believe, was wrongly decided because it addressed the question of what is a campaign expenditure without any consideration or a reference to the 2007 law the City Council adopted several months earlier that actually defines campaign expenditure, Section 370221 of the Campaign Finance Act. It appears that the CFB inexplicably issued an advisory opinion that makes no reference to the law that was directly on point for the question it was trying to answer. Since CFB is not a legislator, we hope it takes careful measure to ensure that its decisions are not legislative in measure. Section 37221B of the Act, which lists the expenditures that are prohibited, does not prohibit the use of campaign funds for ads that include the City Council seal. CFB Advisory Number 2007-6 cannot be considered good law because it did not address the actual definition of campaign expenditure that was in the local law at the time that the opinion was issued. The final 9 expenditures total $5,083.51. These include expenditures for 3 ads, compensation to 2 campaign staffers for work performed in the general election where the candidate was posed on the ballot, as well as for expenditure for purchases at Best Buy, the Apple Store, and Corner Hardware and Paint. In this hearing, CFB staff has the burden of proving the allegations they make. See New York City Charter 1046C2. Even the name of this allegation, we believe, is wrong. The committee failed to demonstrate that spending was in furtherance of the campaign. With respect to each of these 9 expenditures, CFB staff has the burden of demonstrating that expenditures for campaign staff, campaign ads, and campaign equipment or supplies were not used for the campaign. The CFB staff has brought up no proof that would support that conclusion. All CFB staff say is they disagree with the committee's representations about what each of those expenditures were for. In this circumstance, a tie goes to the respondent. To the extent that CFB staff are concerned that the committee has not provided documentation for these 9 expenditures sufficient to meet CFB recording requirements, CFB staff should be treating these allegations as a failure to document transactions, not as a failure to demonstrate that expenditures were in furtherance of the campaign. This is a very significant difference. Under the CFB's published enforcement guidelines, the penalty for missing documentation is 2% of the spending at issue, not 25%. Because all CFB staff are really alleging regarding these 9 expenditures, totaling $5,083.51, is a failure to document the penalty. Is a failure to document. The penalty for these 9 expenditures should not exceed $102 or 2% of the amount at issue. Thus, the penalty for the transactions listed in Allegation 7 should be reduced from $1,501 to no more than $220, which is the sum of $118 and $102. Allegation 8. The allegation is the committee made $8,572.14 in expenditures that were improper post-election expenditures. The CFB staff is recommending a $2,143 penalty, which is approximately 25% of the alleged improper post-election expenditures. We are contesting several of the listed expenditures. Our argument will reduce the proposed penalty from $2,301 to $967. First, 2 of the expenditures were incurred before the November 5th, 2013 election. Crystal Manor, invoice date 10/2013, and Habitat Chamber of Commerce, invoice date 11/3/13. These expenditures total $1,150. CFB Rules 5-03E2I restricts post-election expenditures, but it does not include a standard for what is a post-election expenditure. Rather, CFB Rule 1-08B and 1-08D1 describe when expenditures are treated as pre- and post-election for not subject to the expenditure limits for that election. In other words, under CFB rules, if an expenditure is restricted as a post-election expenditure in relation to the general election, it is not subject to the general election expenditure limit. Because the committee took on the legal obligation to pay these 2 liabilities prior to the general election, that commitment was necessarily for the purpose of promoting or facilitating the candidate's election. In this sense, these expenditures are no different from any other bill received before the election that is not paid until after the election. All such expenditures will be subject to the general election expenditure limit. To treat either of these bills as a post-election expenditure would open the door to a new category of expenditures that are exempt from spending limits. Under that new spending limit loophole, a campaign would become obligated to thousands of dollars in liabilities to build political goodwill before the election, without any consequence under the expenditure limit, and then skip out of paying these commitments after the election pursuant to the CFB prohibition on post-election expenditures. Because the CFB staff allegations contrary to the CFB rules and sensible public policy, these two pre-election bills should not be treated as post-election expenditures. Second, the CFB allegation rejects a $152.42 expenditure to Norton Security Software. This to us doesn't really make sense. The CFB requires committees to maintain access to records and files for 6 years after the election. How is a committee to maintain access to computerized records if it does not have computer security software? This expense is clearly a routine and nominal post-election wind-up cost that is permitted by the CFB. Finally, the CFB staff objects to 7 post-payments made in November 2013 to campaign staff members, which total $3,400. CFB staff contends these were improper staff bonuses. CFB acknowledges that this discretionary compensation was included in the pre-election contracts for these staff members. Page 59 of the 2013 CFB handbook states, on the one hand, that post-election bonuses or gifts to staff are prohibited. But on the other hand, this page permits post-election payment of staff salaries in accordance with existing contracts. In other words, with respect to compensation for pre-election services, such as the 7 payments at issue here, a pre-existing contractual provision for additional compensation may be payable without regard to the prohibition against post-election bonuses. In past cases, the CFB has accepted the permissibility of post-election bonus payments by participating campaigns when the pre-election contractual obligation to pay was not discretionary. Here we can see the pre-election contractual provision for additional compensation was discretionary. Had it been paid before the election, there would be no allegation of violation. CFB staff contend, however, that post-election timing, without more, changes permissible discretionary compensation into an improper post-election payment. We respectfully suggest that the CFB staff is applying the wrong standard. Campaigns should be permitted to enter into pre-election contracts that incentivize superior staff performance with discretionary bonuses. In referring to other contractual obligations to pay staff, the CFB handbook, page 59, makes clear that post-election payments may be permissible as long as payments are not excessive and are in proportion to the size of the campaign and the work performed. As I noted, these payments total $3,400, or 2.5% of total expenditures on the campaign. We submit these payments were not excessive and that they are in proportion to the size of the campaign and the work that each staff performed. When the payments we are contesting, which total $4,702.43, are deducted from the total at issue in the notice, $8,572.14, the remaining expenditures we are not contesting, $3,869.72. A 25% penalty on the non-contested amount would be $967. Lastly, public funds repayment claim, $1,245. This repayment claim is miscalculated. The bank balance is zero. By statute and case law, candidates are not personally liable for public funds repayments under Section 3-712C of the Campaign Finance Act. This repayment claim appears to be an additional penalty for allegations 7 and 8 that is contrary to the CFB's published enforced guidelines. I want to thank you very much for your attention to this matter and my ability to be here and respond to the file.
Thank you. Thank you, council member. Members of the staff?
Yes, thank you. Regarding the failing to demonstrate that spending was in furtherance of the campaign.
Speak up, please.
Sorry, regarding the failing to demonstrate that spending was in furtherance of the campaign, first I'd like to note that Section 370221A and B of the Act are inclusive, not exhaustive. They state that there is a rebuttable presumption as to whether the expenditures listed are in furtherance of the campaign, but that does not mean that only the expenditures enumerated can be the basis for a violation. Second, regarding the Damon Reed expenditures, and this will also concern the Florman Catering, Temple Beth Emeth, and Green Cap United, AO 2007-6. I can't speak to the authorship by the board at the time and the relationship to the law, but that is the AO that is the board's policy, and expenditures that can be made with city council funds, according to that AO, cannot be made for campaign expenditures. I'd also just like to note that the Florman Catering, Temple Beth Emeth, and Green Cap United, the campaign stated in its response to the penalty notice that would not contest the violation or penalty associated with those expenditures. Finally, on this violation regarding the payments to the employees and the burden of proof regarding failing to demonstrate that spending is in furtherance of the campaign, it is a condition as our policy that campaigns that participate in the program are required to produce documentation information to substantiate their expenditures to demonstrate that they are campaign related. And in this case, the campaign did not do so. For the improper post-election expenditures, first, again, for Habnet, we do have an invoice demonstrating that this was for a gala that was after the election, which is in fact not a proper post-election expenditure. It's not a routine expense associated with winding up the campaign, and that is why that was included. The invoice states that the gala occurred on.
Let me ask you a question. If the gala was after, but the commitment to attend the gala was made before, what is your position?
We would say that because it occurred after the election, that expenditure would not be in furtherance of the campaign, and
Even
so
if in, September, you agree, all right, you tell the people, I will attend the gala in November, you think that that's not in furtherance of the campaign?
I believe our policy would be that because the gala itself was occurring after the election, that again, even a commitment prior to the election, and I suppose if the campaign were to demonstrate in some specific way that making that commitment at that time specifically furthered the campaign's interests, we might consider otherwise, but the campaign hasn't done so in this case.
I mean, if the gala was held on October 31st, and it would have been okay, right? So I'm still trying to understand the logic of you go to these galas and you commit to these galas because you think they're in furtherance of the campaign. So if you actually committed before, I'm just not sure I understand the logic of of when the gala is, if it's shortly after the election. I'm not sure I understand it.
I think if we're considering the candidate's actual attendance at the gala as the factor that is in furtherance of the campaign, I think that's certainly much more effective if it's occurring prior to the election. And at some point, you do have to draw a line. I mean, if a candidate commits to an appearance a year from now.
Well, yeah, obviously you have to have a rule of reason, but a lot of these things, you're going to somebody who's a supporter and they say, will you come to the gala? Yeah, I will come to the gala. We'll support you. It's part of campaigning, To me, yes, if it's a year away, sure. But when you're talking about something that's fairly close in time, I'm not sure I understand the difference.
I would say in this particular case, the campaign has not, all we have is this invoice with the date of the gala. We don't have any specific demonstration that this was in furtherance of the campaign, and our attribution.
What is the evidence that there was an actual commitment to the people running the gala before the election?
So I'm not sure how to demonstrate that. We can demonstrate that we attended. I'm not sure what we needed. We gave the invoice. It was fairly close to the election. It was a group and organization that's based in the district, and in furtherance of the campaign, we were supporting a lot of the groups that were doing work in the district.
But is there any indication that did you or do you know of any of your staff members who actually communicated to them before the election?
To the campaign? Absolutely.
I mean, they actually communicated to the people running the event that you would be attending.
Like an email or something?
Or something, or even.
We probably do. I don't have any right now, but we probably have an email exchange where it would say that. The communication definitely occurred well before.
Again, generally speaking, it's our policy to attribute expenditures for something like this to the date on which they occur, and so that's why it's considered a post-election expenditure. And finally, on this point about the employee bonuses, we have accepted bonuses that are specifically provided for in the contract in terms of the amount and the conditions upon which the bonus would be awarded. In this case, it was discretionary, as the council member said, and there was no amount provided, and it was if deemed appropriate by the campaign. This rule is in place to prevent candidates who receive public funds from paying unspent funds that should be paid back to the board, instead just awarding those to their staff as discretionary bonuses. And finally, regarding the bank balance, I believe this was calculated based on the most recent statements we received on from the campaign. Is that correct?
Let me just double check.
Yeah, the memo says that the statement is from a year ago, though, or more than a year ago, so it may actually be
And if the
correct.
campaign can provide updated
Yeah.
statements that show a zero bank balance, we would then update that calculation, but this is based on the most recent documents we received.
Sure. So what we have today, it did get a little complicated because it did go below zero. And it was closed out and we had to pay funding to get it up to zero. So this is my treasurer, Joan Baccarin. What do we got?
So this is from September 10th, and this shows that we had a negative balance.
We have a letter showing that it was a negative balance,
And then we have a letter that we reconciled with the bank and paid off that balance.
and then we have a letter showing that we paid off the balance. I don't know, we don't have a statement that's exactly zero,
No, because they closed the account.
but they closed it. We didn't have access to it, but we have the payment that shows that it was below zero, negative because it accrued some fees, and then we have the receipt that shows that we paid off the negative amount.
On what
We
date was
can,
it
we have,
below
our
zero?
auditors here can certainly consider that. We
Yeah,
just
why-
hadn't
can we
received this
just
before.
make copies of those records?
Sure.
For our records?
This is-
And
That's the last time that we
and-
received, and then-
as we're speaking of records, could you just state your name for the record?
Joan Alexander Bacardine, treasurer for Jumani 2013.
Thank you.
And I have copies
Sorry, go
of
ahead.
my testimony if any of the board members would like.
Yes, I think
That'd be great.
we'll collect copies of the documents that you provided to us today. Could I just ask a question about something that the council member raised having to do with the failure to document? The council member acknowledges that that the campaign did not submit certain documents. He raised an issue about the differential, though, between a 2% penalty versus the 25% penalty. Could you speak to that, please?
Sure. The guidelines provide that the failing to document transactions penalty occurs, it's only for 3 types of transactions: in-kind contributions, joint expenditures, and I'm blanking on the third one.
Loans.
Yes, loans, sorry. Haven't seen that one in a while. And that's a very specific type of, we have the reporting, we know in most cases what the transaction was for, but the documentation has not been provided. For example, in the case of an in-kind contribution, to substantiate the fair market value of the contribution. For a joint expenditure, we need documentation to show the allocation of each share between each of the candidates making the expenditure. For loans, we need the original loan contract and documentation showing interest, et cetera. So the failing to document transactions violation is fairly narrow and applies only to those types of transactions. Failing to demonstrate that spending was in furtherance of the campaign applies more in cases where the campaign has not shown. We see an expenditure either reported or we see it on a bank statement, and we have not received documentation or explanations from the campaign showing that expenditure was made in furtherance of the campaign.
I understand the AO from 2000, whatever, 2007 or 2008.
Mhm.
What is the actual logic behind saying that it's per se, if the seal is on it, that it's not campaign related? Because I could see arguments almost going the other way, that it is campaign related and why you're using the seal. So I'm just trying to make sure I understand the logic that says it's automatically campaign related if the seal is on it.
Yeah, I mean, I was not here at that time. I did
I
not write this AO,
understand.
but
I'm just-
the general principle in here, I believe, is that expenditures that could be made with government funds should not be made with campaign funds. And so if something has the seal on it, that's sort of a per se indication that it's related to the service to the government and that it should have been paid with government funds rather than campaign funds.
And I mean, while the board has, I mean, one of the rationales is that to create a bright line test, to make it clear, you know, when, so that it's easy to see. I mean, so it's like, that's a very bright line test. If it has the government indicia on it, then it's, you know, if it uses, I think also in that advisory opinion, it says if it used the council's address rather than your campaign committee address on literature or documents that are mailed, that kind of bright line test to show, you know, what is campaign related and what is office related, because it is, for elected officials, it is, you know, often a blurry line, but to create some kind of bright line test.
There are a few more rationales expressed here in the AO. One is that to place city office contact information or a logo on a campaign-related advertisement would create a situation in which members of the public might call city offices, encouraging city employees to respond to campaign-related inquiries while at work. Sorry, just reading directly from this. So that if a member of the public sees a logo from the city on a campaign ad, that person might be confused and would contact that person's city office, and that person's city office staff might, not knowing better, provide campaign information during their job at the city, which would be a violation of the charter, which prohibits a public servant from using his or her city position to help a candidate or campaign. It also says that to include city office contact information on an ad or a campaign website transforms the ad from an expenditure furthering a campaign into an expenditure providing constituent services.
I understand the bright line necessary. It seems to make sense with the address. I'm not sure about the seal, but that logic could be used by just using my title as New York City Council member, which I don't think is also applicable here. So I just wanted to make mention of that.
I would say that's probably, I think that's general information that you hold that title. And again, the AO for these are the reasons expressed. It did say that per se putting the logo on or the seal means that it should be government funds instead of campaign funds.
One of the other things here was, photographs at an event, and you said it wasn't you couldn't find it in any particular literature. Now, having been around a lot of events where a lot of photos are taking, I mean, if you have somebody's taking photos for a campaign, is it your position that the actual photo, for the photo to count, it actually has to show up? Because often you'd have a campaign photographer take, 200 photos, and then when you're producing the literature, you say, well, let's take the best 5. So does that mean that the 195 don't count?
I think in this particular case, because specifically we have indicia that the event in question was in Mr. Williams' capacity as a council member, that it's presumed without demonstration otherwise that an event photographer for that event would be related to council business as opposed to campaign business, unless, and something to rebut that presumption would be showing those photographs appearing on campaign ads.
But if you're in a campaign and you're an incumbent for any office, you're an incumbent for the office. And so, if you want to do a campaign that says, your state assemblyman, your controller, you're this in action, I mean, all the photographs are going to be of you doing things as a council person.
Sure. There's also, in this case, the campaign did say that the photographs were used in campaign literature and did not provide samples of that literature as requested. So that's part of it.
That's why I'm going to the question of, does it matter?
I would say that it does, just in terms of, again, we have an indication that this was for a council event, and so something to rebut that, to show that it was campaign related.
And because it
Working
was
the
for
other side.
one specific event. I mean, if this was, and I actually just don't know the answer to this question, but if Mr. Reed was the photographer and took, hundreds of photographs at many different events that, even the ones that were used in the ads or whatever, we didn't question those. It's just this one specific event that was for the street namings. And so that's why it's narrowed to that one event.
I'm sorry, was this for the street renaming?
Yes.
Yes.
Yeah, we have at least one picture here that was used in one of our ads.
So if you.
Right.
So if you can.
Leave a
provide-
copy of
This
that.
wasn't
Yeah,
provided
please.
previously, so
Yeah.
I can't speak to
Okay.
it now.
Yeah.
Sure.
So that's in here.
Any other questions from the board? Staff? Anything else? Ms. Alexander or
ma'am.
council member, anything else
No, thanks.
on these points?
I think we-
So, Ms. Alexander, perhaps if you could collect the materials that you'll be submitting today, that would be terrific, and provide them to the staff, and we'll be able to take a look at them.
Sure.
And
Do we get them back? So-
Yes.
I think we
Okay,
just need.
brilliant.
we just need-
we'll make
Thank
copies.
you.
Yeah, we'll have some.
Great.
So
And
I
a
do have
copy of
one
the
question.
testimony also.
So I have 5 for the board. Do we also need to provide it to CFB as well?
If you could just provide it to the
Awesome. So I've got
staff, that
additional
would be
copies. No worries.
terrific.
Sure. Okay.
Um, Unfortunately, I'm here as a candidate and council member, and there's a meeting I have to get back to at City Hall, so I won't be able to stay.
Thank
for that.
you.
Thank
Thank you for being here.
Thank you very much.
So I'll
Appreciate it.
stay and I'll take care of the dispersal of the docs and retrieval after copies are made. Okay, thank you so much.
Thank you very much.
Thank you. And the next order of business is for the board to adjourn into executive session to discuss pending litigation and these other matters. Is there a motion?
So moved.
Second? All in favor? Aye. The board will go into executive session. All right, thank you for your patience. We'll now resume by voting on penalty recommendations from the staff, and I'll ask the executive director to read those to us.
Okay, first we have candidate Eric Adams, candidate for Brooklyn Borough President in 2013. $500 for failing to provide merchant account statements, $250 for failing to file daily pre-election disclosure statements, $125 for accepting an over-the-limit contribution, $70 for accepting 2 corporate contributions, $225 for accepting 2 contributions from unregistered political committees, a violation no penalty for failing to demonstrate compliance with intermediary reporting and documentation requirements, $700 for failing to document transactions, and a violation no penalty for failing to demonstrate spending was in furtherance of the campaign. Next, we have Kimberly Council, candidate in City Council District 37 in 2013, $250 for failing to demonstrate compliance with reporting requirements for receipts, $350 for accepting contributions from a corporation and limited liability company, $275 for accepting contributions from an unregistered political committee, $100 for failing to demonstrate compliance with intermediary reporting and documentation requirements, $100 for failing to demonstrate that spending was in furtherance of the campaign, $247 for making impermissible post-election expenditures, and $2,086 for late response to the initial documentation request, for total penalties of $3,408. Next, we have candidate Joseph Loda, candidate for mayor in 2013, $350 for failing to file daily pre-election disclosure statements, $950 for accepting contributions from corporations, limited liability companies, or partnerships, $846 for failing to document transactions, $700 for failing to demonstrate compliance with intermediary reporting and documentation requirements, for total penalties of $2,846. Next, we have candidate John Quaglione, candidate in City Council District 43 in 2013, $248 for failing to report transactions, $250 for failing to demonstrate compliance with the reporting requirements for receipts or disbursements, $50 for filing a late disclosure statement, $100 for failing to file daily pre-election disclosure statements, for total penalties of $648. Finally, we have candidate Jumani Williams, candidate in City Council District 45 in 2013, $500 for failing to report bank and merchant accounts used for campaign purposes, $500 for failing to provide bank and merchant account statements, a violation no penalty for a late disclosure statement, $2,150 for accepting contributions from corporations, limited liability companies, or partnerships, $1,050 for accepting contributions from unregistered political committees, $400 for failing to document transactions, $939 for failing to demonstrate that spending was in furtherance of the campaign, $1,767 for making impermissible post-election expenditures, and $500 for commingling campaign funds with funds accepted for a different election, for total penalties of $6,806.
Is there a motion to adopt the penalty recommendations from staff?
Second.
All in favor?
Aye.
The penalty recommendations are accepted. We'll now vote on repayment recommendations from the staff, and I'll ask the director to read the repayments to us, please.
First is a repayment from Kimberly Council, candidate from District 37 in 2013, recommended payment of $1,180. Next, we have Joseph Loda, candidate for mayor, repayment of public funds of $1,135.05. Repayment for John Quaglione, candidate for City Council District 43, of $3,442.84. And for candidate Jumani Williams, candidate from City Council District 45, a repayment of his final bank balance, if any.
Is there a motion to adopt the repayment recommendations of the staff?
So moved.
Second.
All in favor?
Aye.
The repayment recommendations are adopted. Any further business? No? Okay. Is there a motion to adjourn the meeting?
So moved.
Second?
All in favor?
Aye.
We stand adjourned. Thanks so much.